Three in one, that is, we'll give them in three tranches because we have dealt with three categories of matters. So this is in respect of civil application number 161 of 2021. This application coming up before us today for mention, for directions. This is in respect of the IBC matter, sorry, I should have said that. This application coming up before us today for mention, for directions, and having heard the respective counsel and all parties who appeared before us either in person or virtually, as indicated in the quorum sheet, we make orders as follows. We grant interim order of stay of execution of the judgment and decree issued by the High Court in High Court petition number E-282 of 2020 as consolidated with petition number 397 of 2020, E-400 of 2020, E-4101 of 2020, E402 of 2020, E416 of 2020, E426 of 2020, and E2 of 2021, limited to the extent that the applicant, that is the IEBC, shall continue to discharge its statutory and administrative functions, save for dealing with any of the contentious issues arising in the High Court judgment relating to the Constitution of Kenya Amendment Bill, which was the subject of the High Court judgment. We make no orders as to costs. Yes, I say that is 164, 161 only. All right, and these are the directions regarding civil applications numbers 162, 163, and 171 of 2021. These applications came up before us today for mention for directions. They all arise from the same judgment in High Court petition number 282 of 2021 as consolidated with petition number 397, 400, 401, 402, 416, 426, all of 2020, and the 2 of 2021. The respective counsel and all parties appeared before us either in person or virtually as indicated in the quorum sheet. Having heard all the parties and all counsel, we hereby make the following orders. Number one, that in the interest of expeditious disposal of the appeals arising from the aforesaid judgment, all the above applications brought under Rule 52B of the court rules are hereby marked as withdrawn. Two, the appeals arising from the judgment, that is civil appeal number 291, 292, 293, and 294, all of 2021 shall be heard on priority basis. Number three, further directions in regard to the hearing of the appeals will be given in the appeals as I shall shortly read. I think let me repeat the last direction. Further directions in regard to the hearing of the appeals will be given in the respective appeals. And these are directions regarding civil appeals number E291, 292, 293, and 294 of 2021. Having heard counsel and all parties in these appeals, we hereby give the following directions. Number one, the record of appeal having been filed, the above appeals are hereby consolidated and shall be heard together, and the lead file shall be E291 of 2021. Number two, all intended appellants who have filed notices of appeal shall be at liberty to file supplementary records of appeal and or memorandum of appeal as may be appropriate within 7 days from the date hereof. Number three, any respondent intent on filing a cross appeal shall be at liberty to do so within 7 days of the date hereof. Number four, all appellants shall file and serve their respective submissions and bundle of authorities within 7 days from the date hereof. Number five, the respondents shall file and serve their respective submissions and bundle of authorities within 14 days from the date of service of the appellant's submissions. 6, the appellant shall be at liberty to file a reply within 3 days from the date of service of the respondent's submissions. Number 7, the respective submissions shall be limited to 40 pages, font 12, 1.5 spacing. Number 8, the consolidated appeal shall be heard by way of written submissions with oral highlights, limited to 2 hours for each appellant and 2 hours for each respondent. However, the court shall be at liberty to limit the time allocated to avoid repetition. Number 9, the appellants shall be at liberty to make a reply to the respondent's submissions limited to 30 minutes. Number 10, the appeal shall be heard on 29th and 30th of June, 2021, and 1st and 2nd of July, 2021, by a bench of 7 judges of the court. And lastly, the hearing shall be in open court at a venue to be arranged in compliance with the COVID-19 protocols. Those are the directions which the court has given.
Yes, with your permission, my lord.
Yes.
I have made an application to be allowed to adduce further evidence in the form of an affidavit to bring to the attention of the court the joint committee report of National Assembly and Senate.
Please make a formal application. We will see whether it is opposed and it will be before that. Just make it and serve it electronically, and we will give appropriate orders depending on what will be said, because we did not give directions regarding it. All right. Yes.
Yeah. Is it possible to get a copy of
You will certainly get this. Yes, before the end of the day. In a little while, you should get them.
That's very good.
Thank you.
My lord, if I may just ask Considering there might be one or two interlocutory applications regarding additional documents, might it be proper, because the 7-judge bench may not be able to sit until the substantive hearing, if this bench of 3 judges gives us a date where we can deal with any such applications that may have been filed, so that when we come before the 7-judge bench, we are not revisiting those interlocutory issues to do with applications for additional evidence or supplementary record. Thank you.
Just do so in writing, and we will deal with it expeditiously. All right. All right. Thank you, Counsel. The court shall adjourn.